Still looking for Mr. Diaz's. There he is.
Good morning, Your Honor.
How are you, Mr. Diaz? You are welcome to begin anytime.
Thank you. May it please the court. Good morning, gentlemen. My name is Ricardo Diaz, and I represent the appellant Mold and Mitigation of Orlando. This is a third-party property insurance case in which my client contracted to perform a mold assessment on a property that was insured by the carrier. They served their service invoice and were denied. The underlying claim for the homeowner was also denied. There was a show cause order, which I'd like to address real quick, that was entered by the court on October 25th, asking us to secure a final order, namely that would say with prejudice. We believe that even though we were not able to secure such an order, the order at issue is.
Well, let's come back to that. I mean, my understanding is this order granted a motion, and as opposed to just entering judgment or entering a dismissal or rendering one, and then that it is not the final appealable order. Why weren't you able to obtain one?
Your Honor, we diligently tried to secure a hearing, and we filed a motion for clarification with the court with a proposed order, and we were not able to get on the books with the court and get a response from the judge. We believe that this order is de facto with prejudice because once the lower court found that standing was not given and the assignment that my client had was invalid and unenforceable in the Florida law, that it was an incurable defect that my client could not remedy.
I get that, and there's an argument to be made, which of course that I've made my whole time as a lawyer, that this jurisdictional issue is really form over substance, angels on the head of a pin. But nevertheless, an order that just grants a motion is not a final appealable order. So I would either encourage you to continue, because we'll maybe give it another some days, or we'll just have to dismiss the appeal because we don't have jurisdiction. Be that as it may, and I don't know, maybe what you guys may need to do is submit an order to the judge with a letter and a stipulation or whatever, but all a judge has to do is actually dismiss the case versus grant the motion to dismiss. So anyway, on to your argument on the merits.
Yes, on the merits, Your Honor, thank you. As we said, appellant's arguments are twofold. One of them is definitional. The other one's constitutional. I'll address the definitional argument first. And that is that we believe that the instrument that my client took from the homeowner is outside the ambit of 627.7152, and that it does not provide services to protect, repair, restore, replace property, or mitigate against further damage.
But isn't this case controlled by the Kidwell Group case that?
Your Honor, Kidwell is distinguishable as twofold, and I'll address that. Kidwell's guidance with regards to evaluating whether a mold assessment is the type of job that falls in the statute was rendered to, with all due respect, the colloquialism or a euphemism, which was basically, if it walks like a duck, it quacks like a duck, it is a duck. That legal test, if we put it to the test in a law school exam or a bar exam, we would get no points for that. So I don't think it's a great deal of guidance. It didn't peel back the onion on what a mold assessment is and what is not. And what it is not mold remediation. It is not a precursor to mold remediation. Not every mold assessment ends in a mold remediation, as in this case, it did not. We would point out to the court, in our view, a mold assessment is an inspection, a type of evaluation, which is akin to a public adjuster taking photographs to confirm or deny the existence of damage. A mold assessment confirms or denies the existence of spores. And it's basically a tactile visual evaluation. And we believe that because of the Florida statutes that talk about that a mold assessor and a mold remediator cannot be the same entity or person, and I'm speaking about 468.8419, that gives the clear delineation that you can't treat a mold assessment in the same scientific, factual, or legal basis as a mold remediation. You can't conflate the two.
So like in Kidwell, I understand, if I understand it correctly, it involved loss due to water and or mold. Correct. And that was an inspection for all of it versus in your case, it's just mold. I'm trying to figure out how Kidwell does.
Yes, sir. Our case is just mold. And I will point to the court, the procedural posture of the case. Clearly, the court knows that within the four corners of the complaint and its attachment, it's looking to see what the well-pled allegations are by the plaintiff, which are taken as true. And in our case, the instrument that was taken by my client, the complaint and the invoice all clearly carve out the definition purported by the statute, which binds it to the 7 or so enumerated notices and steps that were raised by the FLE in this case. So we believe that factually,
Are you talking about this is not, remediation, this is not repair, this is whatever, or because that was that kind of language was also present in Kidwell, was it not?
yes, sir, but our instrument is slightly
And that's where we get into the duck quacking. Right.
I understand that, Your Honor. I'm just saying that it's not an objective test to use a colloquialism or euphemism for abductive reasoning. I understand that there's some guidance being issued by the court, but it sounds like dicta, not a holding. And if I would just point out to the court in the record between record 1 and 9 exhibit, there's a complaint. In paragraph 14 and 15 of the complaint specifically say that the plaintiff's assignment is limited to the loss assessment services. That has to be taken as true in a motion to dismiss. And number 15, the subject assignment of benefits does not assign or transfer in all or in part post-loss benefits from a person providing services to protect, repair, restore, replace property to mitigate against further damage to the property. Again, in a motion to dismiss, that has to be taken as true. And if you look at the instrument itself, the instrument also says that it's the agent for the job site is only there to perform a mold assessment for the purposes of loss assessment only. The invoice itself, it talks about that the job that was done is a complete assessment of water intrusion damage and limited fungi growth inspection, sampling, laboratory analysis, or report of findings. So we believe that the type of pleading in this case and the type of facts joined together to accept the services that were provided by my client outside the statute. May I move on to the constitutional argument?
Sure.
Okay. Our second.
Mr. Diaz,
Go ahead. I'm sorry. Go ahead.
Mr. Diaz, before you go to that issue, I want to ask one question because the statute in 2022 was changed to add the limitation on assignments for inspections, which I think would include the assessments. So does that establish a clarification of the earlier statute?
Okay, I gather we're back up.
Yep.
Yeah.
Good.
So I suppose we should just pick up and resume.
Okay.
Yep.
Okay. Thank you, Your Honors. We were discussing the 2022 versus 2019 statute. One thing I would like to point out to the court is the holding in the Kidwell case notes that the legislature did not exclude assessment services from its definition of assignment agreement or add such services to subsection 11's exclusion list. And that was the basis of the court's holding. If you look at 6277152, you have this definition of assignment agreement in subsection 6, I believe. And then in subsection 11, the legislature expressly stated what type of assignments the section or the statute did not apply to. And notably, assessment services are not included as an exception in subsection 11. In the 2022 amendment, likewise, assessment services are not added to subsection 11 for the exclusion. I think if the legislature had intended to exclude assessment services originally, they would have made it express by amending subsection 11, but instead they amended subsection 6 to explicitly include inspection services. And under the case law, the court can, and we submit should in this case, find that the 2022 amendment is a clarification of the original statute. And the case law cited in our brief from the Supreme Court says that if the legislature amends a statute shortly after a controversy arises with respect to the interpretation of the statute, then the amendment may be considered a legislative interpretation of the original statute. Here in the record on appeal, it's clear that a controversy arose as to this assessment and inspection services. There were numerous orders presented by both parties to the trial court during the motion to dismiss proceedings that demonstrate that this controversy arose. And you also have the Kidwell case with this exact issue also addressing it. So it's clear that a controversy had arisen and the court should treat the 2022 as a clarification. But regardless, the statute, 2019 statute, does not exclude assessment services from its definition of assignment agreement or add it to the subsection 11 exclusion list. That's the holding of this court in the Kidwell case, and that's binding here. Otherwise, to create an exception here to an AOB that clearly falls within the type of AOB the legislature meant to include within the 2019 amendments would lead to absurd results. This is nothing more than an attempt by the appellants to circumvent the statute and the limitations that are on it. And it's our position this court is bound by the Kidwell case. The reasoning is sound in the Kidwell case. This is a duck under the case law that appellant cited. This is not a pig. This is absolutely services that are part and parcel of remediating or mitigating a property, regardless of whether a separate contractor has to perform the actual repairs due to conflict of interest. So I'll stand on our brief for the remaining points, and unless the court has any other questions, we would ask that the court affirm based on Kidwell and the plain meaning of the statute.
Thank you, Ms. Smith. Okay, Mr. Diaz, 5 minutes to rebut.
Yes, Your Honor, thank you. Just to summarize, my client performed an inspection. Inspection was excluded from the 2019 version of the statute. We've talked about that. As Judge Silverman pointed out, the contract defines the scope between the parties of what they intended to agree to, bargain, and undertake as the services that were provided. I point the court to the fact that the instrument that was taken, the assignment that was taken, is an assignment by virtue of contract, but it does not fall of the type of assignment that is encompassed as an assignment agreement in the definition of the statute. The statutory purpose in this case, it's important to note that there has been no remediation in this case. So we cannot conflate the two in saying that just because mold mitigation has mitigation in its name and they showed up with a contract to perform an inspection, that somehow that falls into protect and repair because a remediation was to take place following the mold assessment. There is no remediation. So as far as the statutory purpose goes, the curb fraud or curb and plead claims, there is no claim in this case, and there's been no proof in this case that there's anything underhanded about what mold mitigation did. There's nothing saying that the invoice is inflated, and there's no actual or potential fraud that's been alleged or proven. Therefore, I would ask the court to please reverse the lower court. Thank you.
Okay, thank you both very much. In order to leave our virtual courtroom, you need to find the button on your Zoom screen that says leave, and you will zoom off into another world, and we'll keep going.
Thank you, sir.
Thank you.
Thank you.